Well, the next case is State v. Williams. Each party will have 15 minutes to present their argument. Counsel, I'm not rushing you, but you may reserve up to 5 minutes for rebuttal. You know how long you'd like to reserve?
I'll have 5 minutes.
Okay, very
Thank
good.
you.
I will keep track of that time up here, and you'll see it up there on the clock. I'll try to give you a warning when you get down to 1 minute in your time if that were to happen. The arguments are being recorded. When you present your argument, please introduce yourself when you come to the podium. Keep your voice up and stay behind the podium because we're also visually recording and we lose you if you go wandering from behind the podium.
Thank you.
Do not use the name of a child, minor, or any victim during your argument, and you can refer to them by initials or terms like the child. And counsel, we've read your brief and are ready to proceed whenever you are.
Thank you very much, Your Honor. May it please the court, I am Alan Medic. I'm here on behalf of the defendant and appellant Jeremy Williams in this matter, and I would reserve 5 minutes for rebuttal. On Mr. Williams' behalf, we've raised assignments of error regarding insufficiency of evidence and manifest weight of the evidence in this case. Mr. Williams was originally indicted on 3 counts. Count 1 being a felonious assault dating from events occurring on or about the 25th and 26th of July 2022. Count 3 being a child endangering charge relating to incidents on that same date. And then count 2 was a separate felonious assault for what were perceived as prior injuries, dating from as early as July 1 of 2021 through that date of July 25th, 2022. When the matter went to trial, the jury found Mr. Williams not guilty of felonious assault in count 1 relating to the events of the 25th and 26th, guilty of the child endangering on that date, and there was a mistrial and a hung jury could not reach a unanimous decision regarding count 2 and the prior injuries. At a later time, Mr. Williams entered a plea of guilty to the conviction to the charge under count 2 for the prior injuries. And we proceeded, he was sentenced to 2 years on an indefinite term on that offense. He was given the maximum sentence he could be on the child endangering charge under count 3 years, indefinite term. And so there is still relief that can be had in this court in terms of the length of Mr. Williams' sentence. A particular dispute, and we raised questions about the sufficiency of the evidence regarding the child endangering. The facts of this case involve, and I'm going to speak only to the events of the 25th and 26th because those, I believe, are the only relevant instances here. We accept the responsibility for whatever happened prior, but those prior acts do not relate to the allegations contained in the child endangering charge. The brief of the state, I think, works to conflate the felonious assault charges with the claims of child endangering. And they are separate analyses and they're separate conclusions that have to be reached. In particular, regarding count 1, which would be the felonious assault directly related to the actions associated with the child endangering, the jury specifically found that Mr. Williams did not cause the serious physical harm. They found him not guilty of that felonious assault. The question left under the child endangering is whether there was a serious risk, there was a substantial risk of serious physical harm caused by the actions or inactions of Mr. Williams in that case. The evidence presented, which is consistent both by Mr. Williams from the time he called the child's mother, through his interview with the police, through testimony at trial, has always been that he was taking care of 4 children that night with his then paramour. They were her children. She was at work. Those children ranged the age of 9 through the youngest, who is the subject of the offenses here, who was at that time 3. He fed them dinner, he had taken care of them, got them ready for bed. He had put one of the children in the shower, gotten that child out of the shower, had put the youngest child into the shower, was at that point on the phone with the mother, and the testimony is such, he said, I have to go, This was about 2:30 in the morning on the 26th of July. And hung up the phone quickly. When the mother came home, the child's head was bandaged. She took him to the hospital, and that's when care center reviews and subsequent actions were taken. The child's own statements are consistent with that analysis, with those statements of Mr. Williams, that the child was in the shower and then he fell and these injuries were caused when he struck his head.
The child was nonverbal.
The child was not nonverbal. The child could not do the care center review because of his serious injuries at the time. I think he subsequently gave an interview at a later date, if I recall the record correctly, in reviewing this. That I think that child was not able to provide testimony at the care center review, but that was due to the urgency and the immediate injuries. He was later able to follow up with those statements that is what had happened. And that is my recollection of the testimony. There is testimony from a child that is what happened. I believe it is from the victim itself. And while it may have been, and I believe the words that the Supreme Court has used in these matters, is imprudent, perhaps even negligent, to have left the child alone. The standard here is recklessness, and did Mr. Williams recklessly create a circumstance by trying to take care of 3 other children and put this child into the shower for a few minutes? I don't think there's any evidence to contrast that that would result in that injury.
What about the time between the phone call that the child's been injured, I have to go, and the time that mother was off of work and came home?
And the question there again becomes, Mr. Williams took care of those injuries as he saw fit. I think in his own analysis he stated that the injury was more serious than he had first anticipated. He bandaged up the kid with the child with a towel or with a t-shirt. It was a homemade remedy. It was not, and again, that may not have been the best solution at the time, but I'm not sure that inaction or those particular actions and not taking all of those children to the hospital and not calling mother to come from work and take them or do whatever we needed to do rises to that level of recklessness. And I don't think there is evidence in the record that indicates that those actions after the fall, I don't think there's any testimony from anybody that inaction either created a risk of greater harm or was the cause of greater harm to this child. That I don't think that created a risk of serious harm. We're not disputing that the injury could rise to statutory requirement for serious physical harm. I'm disputing that this was a child endangering case. This was, I can't speak for everybody. I know I am a parent, and I have raised 2 boys that I've been lucky enough to get into their 30s, and it's just a constant, it's a lifetime of injuries that are going to happen. You look away for a minute, and we have all been there as parents, and stuff happens. Children get injuries, and sometimes children get serious injuries, but not every one of those circumstances, and that is upheld by Ohio law, that not every injury rises to the level of child endangerment. We do not create a criminal liability for every injury that a child faces. There has to be a reckless disregard for known risk, and in this case we do not have that. We have a man who put a child into a shower and then went to take care of other children, to do other things that he needed to do as a caretaker for 4 children that evening. And as such, and there are significant cases. Martin out of the Ohio Supreme Court, where a child was left in a car for a few minutes while the mother returned a gift, was not considered child endangering. Massey, which is also cited in my brief, where a child was unattended in a bathtub for a few minutes, up to 4 minutes.
What about the old injuries? Aren't those relevant to about seeking medical?
I would say that those injuries are, in fact, not at the, first of all, they're not at the core of this child endangering indictment, which stems strictly from the events of that date. Okay? And they are.
Couldn't the jury conclude that there's recklessness and for serious injury?
I would argue that There was no prior child endangering claim here. I don't know that you could reasonably make that. I'm not sure that's a sound legal basis for presuming reckless action on the part of, I think that, that is what led to the mistrial on those prior injuries, was that I think that they could not reach a, and I think that creates a question of inconsistent verdict here, that in both of these counts of felonious assault, that neither of these verdicts were reached. And so a disregard for those injuries, and there is no, outside his later actions in taking responsibility for this, the jury could not say, and I believe that there's no clear indication that whether he was the actor in those prior injuries, or whether it was mother, or whether there was some other person had account for that. So in that regard in particular, I would say that laying all of this at the feet of Mr. Williams would be an improper leap, and I don't know I don't believe that the evidence of prior injury is evidence relating to this charge of child endangering. I disagree with that.
Mr. Hyde, I didn't interrupt you.
Thank you. I will hold on to what I have left. Thank you.
May it please the court, Kevin D. Martino on behalf of the state of Ohio, the appellee, we are asking that this court affirm Mr. Williams' conviction for child endangering because it is supported by sufficient evidence as well as the weight of the evidence. With regard to the facts in this case, the testimony was that the mother left her children, including the child MB, who was 3 years old at the time, with Mr. Williams while she worked the overnight shift from 10 p.m. to 6 a.m. She received a call from Mr. Williams saying that the child was in the shower, which she found unusual. She got a text a little while later saying that the child had fallen and had a little cut. She asked if she needed to come home. He said no. When she came home at 6 o'clock, she found him bandaged, looking very tired. She found, in her opinion, that the injuries were not consistent with what Mr. Williams had told her, and she took her child to the hospital, where the hospital staff treated the child. The social worker at the hospital on page 236 to 237 of the transcript says that the child reported that he fell in the shower and he was afraid of Mr. Williams. 3 days later, when the child was seen again at Children's Hospital, the child could not tell that social worker the source of the injuries, and that's in the transcript on 319 to 326. The injuries that were the basis for the child endangering were not consistent with the fall in the shower. So the argument at its predicate, I suppose, that just leaving a child in the shower alone can't be a basis for child endangering, isn't really an issue before the court, because the facts in the record don't support that this was a fall. The facts in the record support 2 doctors at Akron Children's Hospital who looked at these injuries and found that they were intentional, because this child had lacerated forehead that required stitches, a cut chin, a swollen lip, teeth had to be removed, there was a fresh fracture of the arm, fractured ribs, and a velar fracture, and bruising not just to the face, but the side of the body. And because of those different planes that were injured and the bruising, both doctors determined that that was not consistent with the fall. Dr. Raimondo noted that there is an innate instinct to put your hands out to avoid not face planting in this manner if that had been a fall. The doctors noted that these were issues of multiple episodes of trauma. So I do think that the prior injuries can be a factor into showing whether something is abuse versus a story that a defendant is articulating to go to the credibility of that story. There are all these other injuries that do go to the felonious assault, but the doctors specifically found that there were multiple episodes of trauma, which puts this day as not a fall, but also as a trauma and an abuse, noting that there's multiple areas that were injured. Medical attention was needed. Medical attention certainly was not given until mom came home and then saw these injuries. Therefore, the record has sufficient evidence and supports the weight of the evidence that Mr. Williams created a risk to the health and safety of this child and violated a duty of care by abusing this child. The evidence does not support the story that there was a fall. It is not unusual for a child to come in and repeat a story that an abuser would have said, and then this child did not re-articulate that story 3 days later, when the child was again seen at the hospital. And the medical records certainly are credible. The defendant does not argue that the doctor's testimony, there's some reason to find that it wasn't credible. They talk about multiple claims of injuries, constellation of symptoms, indicating that this was not a fall, that these injuries were not caused by one of the prepubescent siblings who could have potentially, roughhouse with the child. So all the theories about how difficult it is to raise a child without child having, some type of accidental injury, that's all true. But the evidence in this case is completely an opposite as to that being the cause of the injuries to this child. If there are no questions, I rest my case.
Seeing no question, thank you.
Again, the prosecutor insists on talking about things that are related to felonious assault, not to child endangerment. And in this case, the jury found, did not find in either case, Mr. Williams guilty of felonious assault, specifically related to
There's a hung jury, that's not a.
but it is not a finding of guilt. That is, it's very definite, that he was not found not guilty. I'm not saying that, but he was not found guilty of that felonious assault, and he was not found of those prior actions. He was specifically not found guilty. He was specifically found not guilty of claims of felonious assault that evening. So, to suggest that there were other actions that took place that evening, that they say that there were other things that could have led to the only claims in this case are active felonious assault on this child on that date, for which Mr. Williams was found not guilty. And then this claim of child endangering, the only claim, and that is not, those are not analogous charges. The felonious assault does not inherently carry, they're different elements. They're not the same charge. You have to create a situation that creates a substantial risk to the health or safety of the child. And the mens rea in that case is reckless. That is separate and apart from the active intentional harm of felonious assault. And the only evidence, the only issue that could have, the only risk of harm was that in evidence is this period in the bath. And that these injuries occurred when he slipped in the shower. And that is the analysis here, that's what we're here to talk about, because the prior issues, are not related, and we're not on appeal on it. Mr. Williams pled guilty to those charges. We're not here to discuss that prior felonious assault. And even to the extent that that's relevant, this jury could not reach a conclusion that Mr. Williams, they were hung, they did not reach a conclusion that Mr. Williams caused those prior injuries. So for the state to suggest that these are the cause, or this is an analysis of child endangering, it does not balance, it doesn't weigh out right. You can't say on the one hand.
On the first count, the jury found that he caused injuries, but just did not raise the level of felonious assault, just a regular assault?
I think that we are looking at the same, the same standard of serious physical harm in both counts. There's the substantial risk of serious physical harm and substantial risk of self-inflicting, but in count 3, to make it a third-degree felony, there is a specific finding of serious physical harm in the child endangering charge. So I do not think you can separate out those two, because you're dealing with the same level of harm that would have been caused under the felonious assault in count 1 as in count 3. So,
About a minute left in your rebuttal time, Mr. Murphy.
thank you very much. That said, I would go through a couple more of these. There's McLeod out of the 2nd District, where a child on a playground for approximately 10 minutes to a half an hour was not child endangering. Child left unattended outside for less than 5 minutes. Wandering through traffic, not found to be child endangering out of the 1st District. That's Bush, 2020, Ohio 772.
These cases are all about facts that if believed.
And that is very much the analysis here.
But the
Is
jury.
that this is a fact analysis, and these facts do not support this finding of guilt. And that is my statement, is that there are insufficient facts in this case, and that the court erred in not granting the Rule 29 motion regarding the child endangerment. So I would ask that this matter be remanded, and the verdict and the finding of the trial court be reversed. Thank you very much for your time.
The court will take the matter under advisement and issue a decision in due course. The clerk will mail a copy of that decision to you on the day of